Good evening, everybody. This is Jonathan Ginsberg, and welcome back. As you all know, I was out of town last week in Traverse City, Michigan. I'd never been there before. It was actually a very nice place. A nice break from the weather because here in Atlanta, it's about 95 degrees, and it was as low as like the low 60s at times in Traverse City. So that was kind of a nice break. I got to tell you, it was a little weird on Wednesday night not to do a live stream. I've done it for so long that it was just kind of strange not having one. So I'm glad to be back. I hope everybody's had a nice week and you're doing well. And let me know this. I'm actually on a new computer. So I'm hoping that the sound is working fine. If for some reason it is not, please let me know. It tested, it's supposed to be like it's correct, but if it is not right, just put it in the comments and I'll try to fix it. But according to my system here, everything should be working fine. All right, so let's go to the comments. The Dreamers Club says hello. Hope everybody's having a wonderful day. His or her hearing is in 9 days, which you would be nervous. I understand that. And I believe you have questioned, do ALJs have to follow the grid rules? For example, let's say my RFC or residual functional capacity is sedentary and you're 54, following the grid is disabled. The ALJ decide different, even though the grids say that. I have severe emphysema on oxygen 24/7, have mental issues, all documented with med source forms filled up my favor, turned 55 1 month after my hearing. Well, the answer is, the grid rules are not, the grid rules are an argument that you use. And basically the grid rules say, and depending on your age, and if you're between 50 and 54, you would have to have an RFC, a residual functional capacity, at sedentary. Sedentary means standing and walking 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. The big question is, and this is where ALJs have discretion, do you have transferable skills? So question one is the ALJ going to find that you are limited to sedentary work? That's number one. Actually, before we even get to that, point number one is, does the ALJ find that you are not able to do past relevant work? That is step 4 of the sequential evaluation process. If the ALJ finds you can do past relevant work, then you don't go to the grids, because step 4 basically says you are not disabled, you can do past work. If the ALJ decides you cannot do past work because of the emphysema and the medical issues, then the next thing is the ALJ has to decide what your RFC is. And realize that for the grid rules, you've got to have physical limitations. I would take a position that emphysema is going to limit you physically from doing certain physical activities. But again, the ALJ has got to make that decision that in fact you're limited to sedentary work. So if the ALJ decides that you are not able to do past relevant work, step 4, the sequential process. Number 2, the ALJ decides that you are limited to a sedentary RFC. And number 3, the ALJ decides you have no transferable skills. Then by definition, the grid rules apply and you win. So those are the things you've got to convince the ALJ. I've had cases where I have a client who's 54, 53, or 56 or 57, and the ALJ has decided, well, they can go back and perform past relevant work. So you got to get past that threshold. And then the transferable skills. If you did some job where you have skills that would transfer to a very sedentary, sit down type of job where you're really not doing any kind of physical activities, that could trip you up. But generally speaking, my experience is if you've got severe emphysema, you're on oxygen, you might very well meet a listing. Because I believe if you're on oxygen, almost by definition, you're going to be disabled. I also would take the position that if you're on oxygen, there's no way you could do light work because of standing and walking. If you're carrying around a canister of oxygen, that's not going to happen. So I think that the 24/7 oxygen would most likely limit you to sedentary work. So again, you got to look at transferable skills. You got to look at being able to return to past relevant work. But I think all in all, my experience is anybody I've got on oxygen 24/7, I think you've got a pretty good argument there. I think so. I think you're going to win. That's my take. Okay. Jonathan L. He got a remand within a month with the appeals counsel. So obviously you got denied at the hearing. The appeals counsel took the look at the case, and within a month, they basically remanded it because the judge in his decision did not reference any sort of mental health limitations. And again, the way Social Security looks at it, if mental health is a, quote, severe impairment, and realize this 5-step, and I know it gets kind of confusing, but there's a 5-step process they've got to go through. Step 1 is, are you working? Okay, so let's assume you're not working. Step 2, do you have a severe impairment? And it used to be that anything, any kind of reference in a medical record to a condition or anything you claimed was enough to meet a very, very low standard for severe impairment. Now I'm seeing more times when Social Security is deciding that an impairment is not severe because there's been no treatment. So if you've got treatment, which obviously the appeals counsel felt that you did, then there is a severe impairment. If there's a severe impairment, the judge has to address it in his or her decision. So in this case, it appears that the judge did not discuss the mental health limitations, and the AC sent it back and said, no, you've got to consider that. And basically, you have new evidence, and you can put that new evidence into your new hearing. So basically, you're going to have another hearing. If there's new evidence that that's relevant, then that can go into the new hearing. I think it also appears that you ask the judge, or your attorney asks the judge for a medical expert. And it looks like the appeals counsel said there needs to be some sort of medical expert there, or at least the medical needs to, there needs to be, your record needs to be sent out for a medical interrogatory. So it looks like the judge did not do a very good job. As far as any advice, I mean, I think that, this sounds kind of silly. Listen to the prior hearing. Get the audio of it and listen to it so that the questions the judge is going to ask, and talk with your attorney about how to answer those questions better. So the judge, I'm sure, will ask you about your past work. And again, your attorney should probably do a brief to address some of these things. But I think that, listen to the other hearing, the prior hearing, so that the questions are going to be asked. Prepare answers for those. And then as far as the mental health limitations, which were not discussed in the prior case, you and your attorney need to really have a clear line of questions that talks about those things. And the attorney needs to be able to point to the evidence to show that these mental health issues are work preclusive. And, the advantage and the disadvantage of having a medical expert there would be that if the medical expert is not in your favor, the medical expert basically says that there's minimal limitations, you got a real problem, because judges are going to rely on that. But if the medical expert says, yeah, there's some significant limitations, then those mental limitations need to go into the hypothetical question, which is really a residual functional capacity assessment. And your attorney needs to have a very clear hypothetical question prepared that includes all the limitations, including the mental health ones, so that the vocational witness will testify that you would not be able to do work given the scope of limitations. Now, a judge does not have to use your attorney's hypothetical, but you want to make sure that's in there so that you present what they call a prima facie case. So, I think the fact that the appeals counsel slapped the judge down is probably not a bad thing, because judges, they realize that they screwed up. Now you have the advantage of knowing what the questions the judge is going to ask, sort of knowing the approach, knowing the attitude, and you can prepare better. But at an absolute minimum, listen a couple of times, you and your attorney both, listen to that hearing so you know what's coming and be prepared for it. And, your attorney hopefully can give you some advice about, did you answer this question as clearly as you might have? Maybe not. So again, if that's the situation, then you can hopefully make that better. So that would be what I would tell you, and definitely a good luck with it. It's unusual to get an AC remand in a couple of months. That's obviously the judge really screwed up. Justin has his hearing in a month. My lawyer wants witness statements from my spouse. Does it help your case? Can't hurt. I would tell you my experience is that a statement from a spouse isn't going to carry that much weight. Obviously, your spouse has a vested interest in you being approved. It's evidence and it needs, would be considered. Judges will reference it, but usually what I see is if somebody has a statement from a spouse or a child, adult child, or a brother or parent or something like that, the judge will say, it's in there, I saw it, but I'm not giving it a lot of weight because this person's not a medical expert, not a vocational expert, and has a vested interest. A better type of statement would be from a former coworker or maybe a third party who doesn't have your, a financial interest in your winning. Former coworkers are great if you can get something like that. But, getting something from your spouse, especially if it's, your spouse can talk about something that maybe you are not able to really observe because you're living it. If you've got severe depression or anxiety, your spouse could talk about that. But again, the statement needs to be very much about functional issues, how whatever limitations the spouse is going to comment on impact your capacity to function at work. So yeah, absolutely. Put it in there. Can't hurt. Probably not going to help that much, but you never know. Sometimes judges will, give more weight to things, and that may be enough to put you over, put you past the finish line. Who knows? How is Michigan? I talked about this a little bit before. Very, very nice. Actually, one thing that surprised me about it was very rural. We were in travel. We basically flew into Grand Rapids, which is a really nice little airport. It's not very big, and it's really easy to go through. And we had to drive 2.5 hours to get to Traverse City, and it was all farmland. It was really, really just very rustic. And we got to Traverse City. It's a small town. Again, very, it's right on a lake or a bay. It was not, parts of it seemed really nice. Parts of it were kind of a little more, motelish. Not there's anything wrong with that, but, it wasn't a, expensive resort community. There are some places that were very nice. We did take a drive out about 15, 20 minutes, and we went to a farm where we picked cherries. Michigan, or that part of Michigan, is known for cherries. I didn't know that. They have cherry festivals. So there's like you pick it, a bunch of these farms. And so we went to a farm and we went out there and we just picked a bunch of cherries, probably about, we could have picked as much as we wanted and just pay for what you pick. I probably picked about a half pound. That was kind of cool. I really don't ever do that before. And the people were just really, really nice. And then we went to a winery about 15, 20 minutes past that. Beautiful winery. There's a lot of wine vineyards in Michigan. I'm not a big wine drinker. Our friend who we were with is a big wine drinker, and he thought that he tested a bunch of the wines. He thought they were good. He didn't think they were, comparable to what you might get out of Napa or Willamette Valley in Oregon, but he said they were good. But it was beautiful country. So we had a nice afternoon doing that, and then the wedding was where we went to was in sort of a very, probably get about 20 minutes outside of town, just sort of this beautiful rustic, kind of, it was sort of open air, but they did have, I guess panels that came down during the winter, but it was very, very pretty and really very nice. And then we, found a nice bagel place, which was kind of cool. And we ate a lot of pizza, ate a lot of ice cream, which I could find that any place. Actually, some really, really good pizza up there, which was kind of interesting, a little different than when I get here. And then we drove back, and actually driving back, I wish I had a picture of it. We were driving along and all of a sudden a big black bear crosses the road right in front of us. So again, very, very much in the country, which is really surprising. I was not expecting that, but it was very nice. So thank you for asking, Kevin. Cynthia with an I. Hello all. Hello, Cynthia. Jonathan L was waving. Afsena, good evening, Afsena. How are you doing? Tara, we just got we got an approval on Tara's case, which is really very pleased about that. And I know corresponded this past week about some just details, and I really appreciate that. And thank you very much for tuning in. I appreciate the kind words. And yes, please like and subscribe. RD, hello from California, RD. How are you doing? Hope things are nice out west. I've actually been out west a number of times. I have some, I had my two first cousins grew up in Los Angeles. They're a little bit older than me. So when I was a little kid, we'd go out there, probably every couple of years. to LA. Now one of my cousins, he moved out of LA. He moved to Spokane, Washington, where he lives with his family now. My other cousin lives in Culver City, still in California. But we've been out there, a couple of times. Been to Phoenix a few times. It's, nowadays you hop on a plane. It's not as big of a deal as it was when I was a kid. But yeah, it's really, really nice. And LA, we saw some the Huntington Museum. I think my cousin took me to, and I went to the LA Zoo. My cousin's son, I guess my second cousin, he got married a few years ago, so went out there for that. So yeah, LA's California, and we drove through. One time we drove through kind of the middle part of California, which is very, very different. I think there's one place that grows a lot of garlic, and it's California is such a big state. You could actually be a country like Texas, but it was really, really kind of cool. But hello, RD from California. I haven't seen Christine yet, but I'm sure she'll be here. Okay, we've got Darren Magaha. I'm 57 with a GED, unskilled work, morbidly obese, 36-year work history, which is great. Left knee bone on bone, COPD on inhalers, back issues, 5 years in Iraq as a civilian contractor, PTSD. What do I think of your chances? The fact that you're 57 gives you a huge advantage. Age is a major, major factor because now we're in the grid rules. And so you got back issues. So basically, assuming that you've got unskilled work, so there's no transferable skills there, assuming you can't go back to your past work, then, because the past work is, I suspect, more physical, you would meet the grid, the light grid. So even if you could do light work, you have no transferable skills, you're over 55, you have a GED. I think you've got a really, really strong argument under the grid rules, assuming that the CT and X-rays show, and really an MRI probably would be a better test to have, or a helpful test to have in your quiver. But based on what you're saying, long work history, bad knee, bad back, trouble breathing. My book, that's a case I would say that's probably a pretty strong argument. Again, I always like to look at the evidence, but on the face of it, I would take that case. It looks like a pretty strong case. So I think the chances, and you're still working. Yeah, I think if you stop working, I think you got a good argument. Again, I would take a long look at that because I think it's probably a very good case. Let me throw this at you though. People ask me all the time, do I have a good case? And they're still working. And of course, I'm going to tell you, I think you do have a good case based on what you're telling me. I also would tell you that anytime you're working, you want to try to stay at work as long as you can, because realize when you stop working, something significant changes. You're no longer in the workforce. You're not interacting with people, your coworkers, customers, other people out there. You're now sitting at home. It could be 6 or 7 months and you get approved, or it could be 2 or 2.5 years before you get an approval. But basically, you're looking at a indefinite period of time. Even if you're approved, where you're sort of out of the flow of things. You've worked for 36 years. You've been active. You've done stuff. It is really, really hard to kind of go from being active and productive and feeling like you have a reason to get up in the morning to not doing that. So yeah, you have probably a winning case, but there is a paradigm shift when you stop working. That it's hard. It's really, really hard. I think that especially if you have provided for your family and again you've got a long work history. It's going to be a big change, and people get really depressed about that. The family sometimes can, give them a little bit of a side eye. There's no money coming in for a period of time. Spouses and children start to get antsy about that. You may have to rely on family and friends financially. And again, it could, if everything goes well, you get approved quickly. But if everything doesn't get approved right away, if for whatever reason, the state agency doesn't approve you and we're waiting for a hearing, a couple of years. Or I'm trying cases now that, we applied 2.5 years ago. So don't downplay that. Don't minimize the psychological element of having to apply for disability and labeling yourself as disabled. That's really, really hard to do. So yeah, you probably have a winning case, but before you stop working, think long and hard about it. Think about, is there any other kind of work you could do? Um, and of course, get your My Social Security Statement, ssa.gov/my account, see how much you'll be getting, and look and see, if you're getting $1,500 a month, could you get a part-time job where you might make the same amount of money or more? You might be happier. So I just throw that out there, but purely in terms of analysis of your case, yeah, I think you've got, Darren, a pretty good argument there. Bo has a question. I've already applied and uploaded my medical documents to the new upload documents feature they have in the SSA portal. Great. Did this because of the hospitals I went to close down my Sylvia records. I can't tell if DDS got my documents because I can't reach anyone on the phone, either at the field office or DDS. You have to upload doc features used by DDS now. Honestly, Bo, when I upload them, I do it differently. It's probably going to the same place, but we use something called the Electronics Records Express, which is, I have access to as the attorney. And so I'm able to log into all of my clients' accounts. And so when I upload something, I can look and see that it's there. I would think that if it's being uploaded electronically, you don't have to deal with this whole nonsense of faxing it in or hoping it gets there. There's probably a pretty good chance that it's there. But I know it's frustrating when that they can't tell you. One thing that you might want to do is, go to ssa.gov/locator and get the fax number for the office that's handling your claim. You put in your zip code, you get a fax number for the office handling your claim. Fax them a letter. Go to a Kinko's or a library or something and fax them a letter saying, I submitted these documents. Did you get them? If not, I'll resubmit them. That way you have a bit of a paper trail so that if down the road they say we didn't get them, you said, I let you know that I submitted them. I asked you if you had them, and again, all that's going to mean is that, down the road, I don't know what, you can't really do anything about it, but at least it may alert somebody that, hey, you sent it in. That would prompt a call potentially from an adjudicator. Hey, I didn't get this, even though you said you did. So I would just do that. But other than that, you're calling these field offices and DDS offices. It's really, really hard. They're just so overworked. And what they're doing is they offered, a number of months ago, they offered a buyout to a lot of experienced Social Security people, and a lot of them took it. And so then they've got some of these people, this is absolute truth. This is what's going on in Social Security. They took people like that were in the, upper echelons of management that were in Washington, D.C. doing, whatever it is they did, managerial functions and, analysis, data analysis, and they're putting them in field offices and answering phones. And basically they're just restructuring the workforce. The positive is obviously they got people, they have bodies to fill these positions. The problem is these are people that never did this kind of work before. So now you have, executives doing work that they've not been trained to do. And in Social Security, they will tell you that it may take a year and a half to get trained. And I'm looking at this, there's Charles Hall is an attorney. He's got a blog, and, there are comments from these people in the Social Security office, or, they're just are saying that we're just overwhelmed, that we've got, all this stuff coming in and people that don't know what they're doing, trying to handle it. Then there's a listserv that attorneys, we all talk about things going on, and they're talking about, people getting letters saying, we understand that you're dead. I need a death certificate, and attorneys get, and the person's alive, or the person, we got to notice that you moved to Maryland. Well, you didn't move, so it's real crazy out there right now. What I would do, Bo, is, I would, again, you submitted it electronically. I would fax in a letter to the field office or to the DDS office, or both, say, this is what I sent in. Please confirm that you've got it. If I don't hear from you in, pick a time, 3 weeks or 2 weeks, whatever, I'm going to resubmit it because I need confirmation you've got it, and resubmit it. They don't want that. They don't want duplicates, but, I think it's reasonable to say, well, they wouldn't tell me if they've got it. I can't get a hold of anybody. I'm resubmitting it. So that's the only thing you can really do. It's really hard. Or the other thing, again, this is sort of kind of a little more aggressive approach, is reach out to your U.S. Senator's office, and just say, look, I submitted stuff. They won't tell me if they've got it. Can you find out whether they've got it? And, a staff person from your senator's office will contact Social Security, the field office or DDS office. Did you get what Darren, what Bo sent in? And here's what he sent in. Do you have it? And you'll get an answer in a day or two. So those are some of the things you might want to do. And I put this out there before. We've got a survey. We're kind of surveying people just to see what they want from us. So if you have a chance, go to ssdanswers.com/survey and please fill that out. That would be really appreciated. Dennis Pedretti, hope I pronounced that right, Dennis. Being 58, will I get a CDR for SSI? Probably not. I mean, again, I never like to say never, but the people that are getting CDRs, in my experience, are younger people. Realize Social Security has a problem. They have a trust fund that's going to run out of money at current, tax rates and so forth in about 10 years. And, they're looking for ways to reduce the outflow. And one easy way is to do CDRs. But, if you're going to do a CDR, you've got to show medical improvement or something, earnings or something like that. Medical improvement is much more likely for a 35-year-old than a 58-year-old. And at the end of the day, judges don't want to have their time wasted by at a hearing where somebody at 58 years old shows up and says, on a CDR, and, there's no evidence of any kind of medical improvement, waste the judge's time. So it's just not very likely when you're over 55. Is it impossible? No, it is certainly possible. And certainly if you went to work and there's earnings records that are showing up, or they request medical records and they're showing that you've not gone to the doctor, or the medical records show significant improvement, that could trigger it. But, other than that, if everything's kind of the same old, probably not going to be an issue. Rob Tucker got approved over the phone for strictly mental health issues. Depression was the main thing. When you say over the phone, Rob, I'm assuming you mean a telephone hearing, which is really the way, you can do hearings now, telephone, video, or live. And most people the default is telephone, I believe. Some people like to do video where we do it with Microsoft Teams. They use Microsoft Teams for either for video or for telephone. It's just, one just has the video and doesn't. I kind of like telephone hearings because just less things to go wrong. You do a video hearing, people have to have a good internet connection. If they're doing it on their phone, they're doing like this and the phone's moving, that's very distracting. And I've had probably 4 or 5 hearings done by video where somebody's video didn't work. The judge's video didn't work. The claimant's video didn't work. I think one time even mine didn't work. For whatever reason, it's just sometimes it doesn't work. So I like phone hearings. In-person hearings they're now doing again. I have colleagues who want in-person hearings. They think it gives them, advantage for the judge to see them. I'm not sold on that. I mean, I'm getting more, my percentage of approvals is higher than it has ever been with exclusively phone or video hearings. So I just don't buy that at all. I think that people are more comfortable in their homes. I think judges are comfortable. They're in their home offices. I'm in my home office. You have to fight traffic. You don't have to pay $20 for parking. I mean, here in Atlanta, the downtown hearing office is a place called Peachtree Center, which is in the middle of downtown. It's from Atlanta's a very spread out city. From the suburbs, it's a 45-minute to an hour drive. Then you got to pay $20 or $25 in parking if you can find parking. And you're trying to find parking near Peachtree Center if you've never been there. A lot of one-way streets. It's very stressful. They do have they have something called MARTA, public transportation. Some people not real comfortable with that. They've never taken it before. They don't know what station to get off of. And literally when you get off on the Peachtree Center station, there is an escalator. I kid you not, it is almost straight up vertical. If you're claustrophobic or you have fear of heights, this thing will freak you out. It is a long, long escalator that goes straight up. Then you got to wind your way through a food court, find the marquee one tower, which is from the back. I mean, if you've not done it before, it's stressful. I mean, I've done it enough times where I know where I'm going, but it's very, very stressful. Telephone hearings eliminate all that. No parking. You're in your home. You're comfortable. You and your attorney can prepare. You're at the same at home. It's just much easier. So my feeling is, a telephone hearing is really good. So it looks like, Rob, that's what you had. If that's the case, that is good. Okay, Jonathan says sounds great. Okay, good. Yeah, I just again, it's a brand new computer. I got we went to Windows. I'm a Windows office, so we changed it to Windows 11. So I took my old computer, and my wife's a workers' comp lawyer, and she's got a computer that's like 10 years old, and it's Windows 10. It's too old to really upgrade. So I gave her my old machine, and I use this one for video editing and photo editing and things like that. So I've got a lot of memory and all that stuff in there. So I gave her my old one, which is still 5 or 6 years old, but it's about 10 times more powerful than what she's got. So my computer guy took my old machine, put Windows 11 on it, restructured, reformatted everything, added new memory, hard drives, and all that stuff. And this new one is like super fast and all that kind of stuff. So I really haven't even had a chance to do anything with it. I'm still loading programs on it, but whenever you change something up, in fact, right before I got on, I realized I didn't select this microphone as the microphone. It was another microphone, and my the speaker was not the same. So you have to do all that stuff there. And I knew, Vince, you were going to ask me about that. Let me see if I can show you here about Moomer's ice cream. I think I did a picture here. Let's see. There we go. I don't know if you can see this or not, but there we go. So I took a picture, and yes, I did have some Moomer's homemade ice cream. It was really good. And having an ice cream is not a tough sell for me. Ice cream and pizza are not tough sells. Unfortunately, they're not tough sells. But yes, very, very good. And thank you for pointing that. I told everybody I was eating. I'm like, my buddy Vince, who's one of my clients, one of my live stream guests, visitors all the time, says, go to Moomer's, going to Moomer's. So I absolutely did. And thanks for the recommendation. VV20VV, just want to say thank you for giving me the confidence last year, telling me I think I had a solid case, even though I represented a location, won my case. Good. That is great. I'm glad that you won your case. And, again, I think that, and I talk about this a lot in my videos, which I'm going to be doing a bunch of new ones. I'm done with my hearings for July, so I'm going to do a bunch of videos the next few weeks, try to get some new stuff out there. I think that, when you are pursuing disability, and I just talked on this a little before, you have to be prepared psychologically to kind of go through with it. But you also want to have the attitude that you bring into it that you don't want to be pursuing disability. You have no choice. You're a reluctant claimant. And judges pick up on that. They really pick up on people who are, they feel are really fighting the idea of being on disability, as opposed to people who sort of decided, I'm disabled, pay me. And, if you are disabled, if you've got a significant medical problem, you don't need to apologize for it. I mean, this is not something that you wanted to have happen. And that's, again, the attitude to bring. I didn't want this to happen. I didn't want to have a herniated disc. I didn't want to have, breathing problems. I didn't want to have, chronic kidney disease or, uncontrolled diabetes. It's just happened. I've done everything the doctors have told me. And, I'm pursuing this. I paid into it. I worked really hard. As much as I'd like to go back to work right now, I can't. I will continue to try to fight to go back to work. That is the attitude you bring to it. But I don't think, and again, there's some judges, not a lot, but a few sort of have the attitude like, well, everybody here is trying to pull something on us. Yeah, that's just not the case. I think it's really you have a right to pursue disability if you are in fact disabled. And I think judges, in my opinion, owe it to everybody who's pursuing this to show them the respect that it's not an easy thing to do. There are a few judges I know that don't do that. They don't seem to. There's one judge in particular I've been in front of a number of times. He talks really fast, rushes everybody through it, cuts people off. Like, what? It's hard to pursue disability. And, show some respect to the people out there that are, paying your salary, judge, that your tax dollars are paying your salary. Most of them are going to do that. A few are not. And again, you hope you don't get one of those judges that does not do that. Socialista, can you get your own FCT? You have to order it. I think you're talking about functional capacity test. You can get your own. You can go to a physical therapy clinic. That's typically where you get them for physical. And these are standard tests. It's a physical functional capacity evaluation done by a physical therapist. It may be a 2-day process. It's used a lot in workers' compensation, long-term disability, but you can go in. It may cost you $500, $600, $700. Of course, or you can get your. That's one way to do it. A formal where they actually have you pull down weights, or they lift and they observe what you're doing. That's one type of physical functional capacity. Or you ask your doctor to fill out a form. And again, there's a number of places you can get these forms for free. I'm going to put a couple of them. Here's one where you can go here and get free functional capacity forms. If your doctor will fill it out, you can absolutely use that. So, I think that you can get your own. You don't have to have Social Security, send out for one, but you can get your own. So, and I do all the time. In fact, I'll give my, I have functional capacity forms for multiple medical conditions. I'll give it to my client and say, take it to your doctor so we can get it filled out. And, as long as we've got medical records that are consistent with what that functional capacity form says, we're golden. We're golden. All right, Rodney, one of my longtime clients. Good to be back. Thank you, Rodney. Bo, got the pain and headache questionnaire 4 days after it was sent to DDS. Does this mean it was assigned to an examiner? Rarely hear anyone talk about these questionnaires before. I wrote a lot. The questionnaires you're talking about, and Bo, I think you were asking before about submitting records. You don't know if they were actually received. That was what you'd asked before. And now you're asking about, you got these questionnaires. I don't know that I would say there's a relationship between them receiving your records and you're getting the questionnaire. Maybe there is, maybe there isn't. What my observation is, adjudicators are sending out forms, to show that they're working on the file. They've got to develop the file. And, some of them send these forms out legitimately to find out what you have to say about your headaches and about your pain. Others, quite honestly, are doing it to give you something to do so that it looks like something is being done. I get people complaining sometimes to me and my clients. They've been given the same form 3 and 4 times. Like, aren't you going to read it? It's the same thing. And so, in fact, this was a discussion on the listserv this morning. Somebody said, my client's gotten the same form, every 3 months. And, what do I do? And somebody says, well, just take a copy of the previous one and write, nothing has changed, and resubmit it. I'm not sure if I agree with that, but, I think the forms, definitely spend some time doing them. If you can find one tip I would give you, if the forms are, forms like the 3368 or whatever, look it up online, see if you can find it online and fill it in, type the answers in, don't handwrite it. I look at all these files and I'm looking at files, every day. And, I'll see these forms that are handwritten and sometimes they're hard to read. And, I suspect that a busy adjudicator is just going to not spend a lot of time, or a judge and spend a lot of time with it. So if you're going to handwrite it, either take your time, find somebody in your family who's got good handwriting, or find the form online and type it in. I think that's much, much better, much more effective than to handwrite it in with a bunch of notes in the margin. I mean, I can show you forms where it's just, just stuff all over the place. There's things in the margin. There's, arrows pointing here and there. Judges aren't going to read that. It's hard for me to read. Look, I mean, what I'm doing now is I'm starting to use more AI tools. Notebook LM is the one I use mostly for hearing prep, which is a Google product and it's closed, meaning I give it information and it only uses that. It's not open to the whole internet. So I'll give it the exhibit file. I'll give it sample briefs. I'll give it a link to the grid rules site. I'll give it a POMS regulation. I'll give it sample paragraphs, things like that. And I'll say, let's draft up a narrative summary or a draft pre-hearing brief or something like that. Well, everything in that file, that exhibit file is OCR, the optical character recognition. It can't OCR a handwritten form with notes in the margins. So it won't use that. And I suspect if it's not already happening, it will happen soon, that judges are going to be using these AI tools to summarize medical records. I mean, it's gotten to the point, I will tell you, that you can put a bunch of stuff into an AI engine like a Notebook LM or the paid version of ChatGPT or Gemini or some of these other ones, and ask for a summary, and it will give you a summary. I mean, and I've done this for a long time. So if I have a good summary and I talk to my client, I could literally try a case, in 45 minutes. If I have the summary from an AI, talk to the client, I can be, I wouldn't be as ready as I would like to be, but I would not be unprepared. Whereas I could never do that before. So I suspect that if I'm doing it, if I'm taking advantage of these AI tools, I know that judges are. I know that Frank Bisignano, the new commissioner, very big proponent of using AI. So that's coming. So, you're much better off, in my opinion, filling out the forms using that are typewritten, where you download the form and write it in with typewriter as opposed to handwriting. Handwriting is just really hard to pick up, with a computer. So just whatever it's worth, that's what I would tell you. Socialista, good evening. Hello, Socialista. I think you just had a question about the functional capacity test before. Muley, how can SSDI find you disabled as of your 55th birthday for your onset, but your medical records were 2 to 5 years before? Because what's happening is, and I'm seeing this a lot as well, they are basically finding you disabled at 55 because they're saying now you're limited to light work and you grid out at 55. So, this is a real problem. I've got probably 8 or 9 cases right now where I got an approval, but they changed the onset date and cut my client out of a year, 2 years, 3 years of past due benefits. Sometimes we appeal that, sometimes we don't. I tell my client, I'll do the analysis and I'll say, look, and I'll figure it out. You can look, because the letters will tell you how much money they're getting. If it's $10,000 or less, probably not worth taking the risk, because realize if you appeal it, you go in front of a judge, you could lose. Now, is it likely you're going to lose if you got approved at the administrative state agency level? No, but what if you get a bad judge? You could end up losing. So you have an approval over here, you have a risk, you don't know who the judge is going to be. Once you make that decision to appeal, you're kind of stuck. So, if it's 8, 5, even $10,000, probably not going to tell you to appeal it. $30,000, yeah, I would take a long look at it. I've got 2 or 3 I've done this year alone, and we've won. We won at the hearing where it was a $30,000 difference. In fact, I had one, I remember, where the judge, it was interesting. The judge apparently had not really prepared very well. So he said to me, would you consider amending the onset date to your claimant's 51st birthday? I said, Judge, the state agency did that. We appealed it because the evidence is overwhelming that he was disabled at 50 or he was limited to sedentary. Oh, okay. And the judge approved it. But, they're looking for ways to save money, and really easy way to do it is to cut you out of past due benefits. But that's what's going on. 55 is kind of it's a lot easier to approve somebody at 55 because if you find them limited to light work, they meet the grids. In fact, I have to think twice, and I'll be honest with everybody. If I have somebody contact me and they're 53 and, it's kind of questionable whether they're limited to sedentary, the problem with a case like that is I take it by the time we get to the hearing, they're going to be 55 in 3 months. I've had it happen a bunch of times where a judge approves me at 55, no past due benefits. I don't get paid. Client doesn't get past due benefits. Nobody's happy. It's a problem. It's a real problem. And because obviously, I'm here because I want to share what I know, but I'm also, I got to keep my lights on. So, there's sometimes where, that can be a real issue. If I sense that the person would be coming up for a hearing right after their 55th birthday, may not be a case I can take because the risk is too great that I'm not going to get paid. So, it's just, it is what it is, but that's what's going on, Muley. That's what's going on, Muley. Dreamers Club was the person with the emphysema we talked to earlier. Never sent me to any of their doctors, no consultos. Will they rely on your doctor's MedSource forms? Probably. The medical expert is pretty uncommon. I'd say 5% of hearings, you'll see one. So it's really, really uncommon. If there's no consultative in there, you've got good medical records, you've got forms from your doctor, there's a pretty good chance that, that's going to be enough. to get you over the finish line. And if for some reason there is a medical expert there, your attorney can cross-examine the medical expert, because again, this is a person who's never examined you. And the question you ask is, well, the treating doctor who's treated this person for 5, 7, however many years made these conclusions. Are you saying that's, on what basis are you telling me that that's wrong? And the medical experts will always say, well, I can't say it's wrong. I'm just, raising the point that it may not be. Well, I think it's better evidence. The argument I would make is it's better evidence from a treating physician who's seen the person, who's got an opinion, as opposed to somebody who's only looking at the medical record. I had a medical expert in a hearing about 3 or 4 weeks ago. And I think I told you all about this. The first hearing, there was a hearing, and the judge sent the record out to a doctor, the record and interrogatories to the doctor. The doctor writes all these assertions about my client's capacity. I have a chance to object to it. I objected, saying this is conclusory. It makes no sense. I want a hearing. We got a second hearing, different medical expert who had a hard time getting on the phone. We get him on the phone, and he's like, well, I'm like, and so I kept saying, is it unreasonable? My client's had 3 back surgeries. Are her complaints of pain inconsistent with that? Well, they're not inconsistent with it. Some people have that, some people don't. Well, if she's saying she does, is there anything suggesting that she's malingering or secondary gain? No. Okay. Case gets approved. So, just because you're a medical expert doesn't mean you're absolutely going to lose, because the medical experts are looking at the medical record and they're saying, well, the medical record does not definitively say the person's disabled, but it doesn't, factor in, and I'm not factoring in subjective complaints of pain or other limitations. So, it's just going to really boil down to what the judge thinks. But, you can always get a medical expert to back down by saying, I didn't see the person, I don't know this person, and I'm not considering their subjective complaints of pain, if these are not inconsistent with what I'm seeing in the record. Vivi is 41 years old, and you won. That is awesome. That's a real accomplishment, I will tell you, real accomplishment. Bala 2001 had an evaluation scheduled last Friday, got postponed because you hurt your knee. And now on the 31st psych evaluation, knees. Afsana is one of our clients. I think I know we've been talking to you. I don't know if we formally have been retained or not, but we're close to it, if not already. As far as the evaluations, they're going to do these evaluations are generally going to be about an hour long. They're going to do some testing. My experience has been generally that if it's physical, like an internal medicine doctor doing a physical consultative, it's not going to help you very much. A breathing evaluation is going to be basically giving you pulmonary function test where you're breathing into a machine to test your breathing. That's just objective. It'll determine what your breathing limitations are. The psych evaluation is going to probably be a little more helpful because the doctors that do this are practicing psychologists. And they're not looking for reasons to make you, to deny your claim. So you got to go, tell the truth, if I get a consultative evaluation that is not consistent with the rest of it, I object to it. I'll ask the judge to give it minimal weight because it is based on a 30-minute evaluation. I would tell you, Asena, write down exactly what's happened at these evaluations so that, if it comes down to having to, talk about it at a hearing, you can tell the judge. I went in for this appointment. I was there for a total of 30 minutes. He took my pulse. He checked my reflexes. He asked me to sit down, stand up and sit down off the table. And that was, and I walked around the room, and that was basically it. And I think judges know that many of these consultatives are kind of a waste of time. But, I think that's useful to be able to describe what happened. But, they're going to be part of the record. And a judge can certainly use that to deny a claim. But most judges, my experience, are going to rely more on treating records as opposed to the one-time consultatives. Jonathan L., from one Jonathan to the other, you are very, very welcome. Jack Sizz, what can medical offices do to make your job easier? I think the main thing is get the records into Social Security when they're requested, get them in timely. Don't make them wait. Don't make them request it 3 or 4 times. I think that when they, if you're obviously if you're asking your doctor for a functional capacity evaluation, have them cooperate to do that. That's really the main thing. I think that there's way too many times when I'm looking at a denial notice and it will say, we made a decision based on the following medical records, list them. We could not obtain records from ABC Hospital, Dr. Jones, Dr. Smith. If Dr. Jones is a treating orthopedist, that's a bit of a problem. And a lot of places now have portals where you can get the records and we will get those and upload them. But this goes to the point that I think it was Bo said before that, how do you know that they're getting in? Well, again, I can tell because I can look on the file. If you're doing it on your own, you may not be able to tell right away. But I think the main thing is, tell the doctor's office when you get this request from Social Security, respond to it quickly, get the records in. And so that way, you have a fair chance of having them look at everything. Many facilities, many hospitals and doctors' offices, especially big practices, are part of this, something called the HIT system, HIT, Health Information Technology, which allows Social Security to get the records quickly and pretty much automatically. So if your practice is part of that, that's going to make life a lot easier. If it's not, they may have to mail them in or send them in electronically somehow. But just have them, that's the main thing. It's just doctors' offices. And again, just so you understand why, doctors' offices deal with lawyers' offices all the time. They have to provide records for legal matters, whether it's personal injury, which is very common, workers' comp, medical malpractice, whatever it may be. And in the personal injury world, most states, or just in general, most states allow doctors' offices to charge like per the page. So to get medical records, if I was a personal injury attorney, I'm getting medical records, it may be $250, $300 for those records. It's a profit center, I think to some degree, or at least a break even for many practices. Many of them use these records companies like Ciox. There's a couple other ones. And so if they get a request, they'll send back, oh, no, Social Security says, we want the records, we're going to pay you $20. Ciox writes back, oh, no, it's going to be $350. Social Security says, no, it's only $20. And there's a standoff. And sometimes the people at Ciox realize, okay, we got to provide it. It's a federal agency asking for it, or if it's an attorney, sometimes they don't. And so a lot of these records don't get filed. So more and more, and this goes again to what Bo said, I'm looking at the file, my staff is looking at the file electronically to see what's there. And more often than not, there's something missing. And so we have to go track it down, get it in. But that's really the main thing, is just, tell your doctor's office that Social Security doesn't pay very much. I think it's $10 or $20, but it's a federal agency. It's really necessary for your case and to cooperate with them. And I think that will go a long way to make my life easier, certainly. Zippy, 60 and a half years old, been an SSDI since January of 22. My awards letter says CDR in 5 to 7 years. Onset date 2019. What are the chances? Very, very low. You're close to retirement age. You're just not the target. Target is a 35-year-old, not a 60 and a half year old. So is it impossible? No. Is it likely? Very, very unlikely. Mama Deb, I'm unable to apply online because in 23 I started taking Social Security benefits early due to the start of the difficulty. What do I need to apply by phone? You could apply by phone, or go into an office, but I would probably apply by phone. This is one of those cases where, you probably need to apply by phone. I don't envy you, going down the 800 number, waiting online. Give yourself 3 or 4 hours. Get the packet. Go to the ssa.gov/apply for disability. There's a packet there will tell you what information you need. So go ahead and get that. But yeah, you'll probably have to do it by phone, unfortunately, if you can't do it online. And by the way, we've got several of these where I can't file them electronically. One gentleman who's on here sometimes comes to live stream, and doing it on paper is a nightmare. It just slows everything down. And, he'll log into his my Social Security portal, and it'll say, case closed or something like that. And we, of course, call them, it's not closed. So, it's really not a good thing to have it done on paper, but, it is what it is. I mean, this is just part of the thing we're dealing with. Kelly says, thanks for all you do. Thank you very much, Kelly. Appreciate it. I'm at recon 10 months for congressional inquiry. How long do you think till something moves? Probably a few weeks to a month. I mean, congressional inquiry will get a response pretty quickly. You did the right thing. 10 months at recon is too long. I would say you should have some word in the next 30 days. Most of the time, whenever my clients do a congressional inquiry, and most of them are doing them now at my suggestion, you're going to get a response pretty quickly. Socialista, yes, Michigan has the best, has some of, not the best charities in the country. Use helicopters to drive them so they don't crack. Didn't know that. And yeah, it was actually interesting at these orchards. There were like 3 or 4 different varieties, the darker ones, which were a little more tart, and the sweeter ones. And it was kind of interesting. In one orchard, they had 3 or 4 different varieties of cherries. And, of course, we would, take a couple and test them. But, sometimes you'd shake the tree to make them fall down. It was really cool. And I didn't see a lot of insects up there either, which is kind of interesting. Maybe it's just because it's a little cooler climate. But the cherries were delicious. And, I mean, that's it's a great fruit because it's kind of anti-inflammatory, but it's really tasty. So I'm a big fan of cherries. So that was great. Tanya Carr, I have a daughter of 32, quad cerebral palsy, 24-hour care, wheelchair bound, special needs, trust. Can she still get disability? She's going to be SSI only. So we're kind of venturing into an area beyond what I know. But if the special needs trust, what the issue you've got to get away from is, any support she's getting from family. How do you make that not be considered an asset for SSI purposes? The special needs trust might be enough to do it. It's just something I don't deal with. Really, an elder care lawyer would probably be somebody who could answer that question, believe it or not. Elder care special needs lawyers could probably answer that question, but she certainly qualifies medically. The question is, how do you make sure that there's no problem with her, any sort of assets? And, is there, if it's not even about the SSI, it's about the Medicaid, can you get a waiver? Again, beyond a little bit what I do, but I think an elder care lawyer, special needs trust lawyer should be able to help you with that. But she's certainly qualified medically. That's mad cool. Nobody's ever called me mad cool, but I'll take it. That's nice. Michelle Leidy, I'm 59, had fallen and broken your upper arm and bone went through the radial nerve, have no feeling in lower arm and hand, wrist drop, can't use fingers, have been a nurse the same place. Do you have a case? Well, I mean, I think that you can't go back to being a nurse clearly with one arm. So I think that gets sort of past relevant work. The question is, are there any transferable skills that you've acquired that would transfer to a sedentary job that you could do with one hand? And do you have any pain? You have numbness, you mentioned, no feeling. Do you have pain there? Is it just pure numbness? I think that, you can't go to past work. There's probably not your transferable skills. If you're limited to sedentary, which I guess my analysis would be this: you're 59, you cannot use one hand, one arm. I don't see how you could do light work. Light work is lifting 20 pounds on occasion with one hand. I can't see that happening. And you can't really use the other hand, no feeling in it, wrist drop, and so forth. So that tells me you're limited to, at best, sedentary work. And I think that's probably questionable. If you're limited to sedentary work and you're 59, the grid rule says that there's probably no transferable skills. you're limited to sedentary. I think you meet one of the sedentary grids of the 201 section. Go to grid gridrules.net, and I'll give you the grid rule in particular. I would look at grid rule 201.06, which is a high school grad or more, no direct entry into skilled work, semi-skilled or skilled work, no transferable skills. That's you. And then you've got something called the POMS regulation. And the POMS regulation stands for Program Operation Manual. And I'm going to give you that as well. If you will bear with me here. All right, so what you want to look at, two things you want to look at. Go to gridrules.net. I'll just share my screen. It might be easier to just do it that way. Share screen. Okay, so first go here. Go to gridrules.net and go to the sedentary grid. And if you look at 201.06, I think that applies. You're 55 plus. You're limited to sedentary work, which I think would be, sit down work. You're not going to be lifting 20 pounds. You've got semi-skilled work background, but no transferable skills to sedentary, and nothing that provides direct entry into skilled work. You're not going to be able to use the keyboard because you only have one hand. So I think you're disabled there. Then we have something called the POMS. And the POMS are, let's go to that. Let's go to share screen. And the POMS are the Program Operations Manual. And the one I'm looking at is DI 25015.017. So just type in POMS, POMS, DI 25015.017, transferability of skills analysis. And what it says down here is that if you are limited to sedentary work, okay, and you meet this 201.06, which is what we just talked about, all right, to do a vocational adjustment, meaning to determine whether you have capacity to adjust to something else, there's something called the very little, if any, vocational adjustment standard, which applies. And basically what that means is that Social Security have to prove that there's a job that you could do that basically requires almost no retraining. So they can't expect you to go into a different industry out of nursing. So I think when you combine 201.06 and the POMS regulation, you win. That's what I would argue. And I think that based on what you're telling me, that's the argument that would carry the day. So again, if you can do this on your own, ask them to analyze your case under Grid Rule 201.06 and POMS 25015.017. I think you have a really good shot at winning based on that. Michelle. Okay. Tanya Carr. Okay, I think we've already talked about that one. Dr. Wright. Filed for SSDI in Florida. 3 months ago, this week, got a letter of DDS contact. It's an office in New Jersey. Any reason? Yes, because either somehow they decided you live in New Jersey, or B, the Florida is so backed up, they decided to have it transferred up there to be developed. And we're seeing this more and more. State offices are overwhelmed. I can't imagine that New Jersey is not busy too, but I'm seeing judges assigned from different states, DDS offices. It's just because they're trying to maximize capacity. That's just why. There's no other reason other than internal workings of Social Security. Socialista, I'm 59, I've been disabled for 15 years. Okay. Now, the question is, have you not worked in 15 years? Because if you haven't worked in 15 years and you're just applying now, you're not going to be insured. Or your insurance probably ran out about 10 years ago for SSDI. That's problematic because while you can argue that your disability began 15 years ago, trying to convince a judge that's the case, really hard. 15 years ago, you were also 40 years old, or in your 40s, I should say. 44, something like that. So, if you're not insured, go to ssa.gov/my account to see if you have enough credits. That's going to be a problem. So medically, you might qualify. You might be disabled medically, but you may not have the credits for SSDI. You could pursue SSI, but that's going to be subject to all kind of offsets for household income and assets. Okay, Corleal. Hello, Corleal. How are you doing? Do all SSD lawyers do pre-hearing briefs? Just curious, if I could ask my lawyer that. Not all. I mean, I would say I do them about 90% of the time. Every once in a while, I will not do one. And I do that for strategic reasons. One is if I have a case that is kind of light on the objective evidence and I'm relying mostly on my client's testimony, I think a pre-hearing brief kind of highlights the fact that there's not a lot of objective evidence. So I don't want to do that. And I'll just make my argument and then put my client on the stand and hope that the judge will rely more on that. That would be one reason I might not do one. There are just other cases where the medical evidence is sort of all over the place. There's evidence helpful, there's evidence not helpful. And it's just, I can't really get when I'm doing the brief, I'll start working on one because I typically start one in every case just to help myself prepare. If I can't get a flow going, like I can't get my argument really flowing together, I'm not going to force that. And then I'll again, just make an opening statement and then question my clients. It's really kind of a gut feel. If I think it's going to, not going to help, I won't do it. Most of the time, I think it's worthwhile to do because I think it does a couple of things. One is it sort of crystallizes in my mind the arguments I'm going to make and the facts of the case. I think it also sends a message to the judge that I'm prepared and I've highlighted the main issues. Judges appreciate it. They see that you're doing work. You're trying to help them get through this. I mean, I had a case a couple weeks ago, about a couple weeks ago. Record was 5,000 pages, and my client really wanted to be heard. And when we were doing our pre-hearing, I would ask him a question. He would get into long history. Really bright guy, very nice person, very sincere. But I was having a hard time getting him to stick to the main issue. So I did a pre-hearing brief where I really spelled out the main issues. And before the hearing, I had a brief pre-hearing conference with the judge. And I said, Judge, and for the first thing she said to me was, thank you so much for the brief. When I saw 5,000 pages, literally, she says, I almost started crying. To have to go through 5,000 pages was going to destroy my weekend, And she goes, I saw your brief, and it's like, okay, this is great. And this really helps me a lot. Second thing I told her, and I was honest there, I said, look, my client has been, he worked really, really hard for a long time. I think he's got a legitimate, strong case. But he wants to be heard. He wants to tell you about his history. I said, and he will talk. I mean, he's a talker. Nice guy. And she's like, I get it. She goes, look, I'm going to approve your case. She told me right before the hearing, I'm going to approve your case. I just got to get enough on the record so that if it's looked at by somebody else, we cover our bases. So I appreciate you telling me that. If he starts to ramble, I'll cut him off politely. You can cut him off politely, and we'll get through. And my client, to his credit, did not really ramble. He was, because I really read him. I wouldn't say the riot act, but I just really emphasized the point. You got to be concise. If the judge says, how long can you stand? You don't need to give a history of standing. You have to talk about what it was like 20 years ago versus now. I can stand for 10 minutes, but you don't need to describe why you can't stand. The judge just wants to know how long you can stand. And he did a pretty good job, I think, overall, in not getting off on a tangent, a little bit, but not nearly as much as I'd feared. But the judge was very pleasant. She was very direct. And when he would get off track, she would rein him in. I didn't really have to. And, after I asked if I kind of covered the main issues, she turned to the vocational witness, asked one question, boom, no jobs, we win. And, told my client afterwards, I said, look, I just want you to know, before the hearing, I talked to the judge. I knew we were going to win. I just want to make sure that we didn't do anything to pull defeat from the jaws of victory. Long-winded way of saying a pre-hearing brief most of the time is a good idea. Every once in a while, I think it could create more problems than it's worth. But for me, 90% of the time, 95% of the time I do one. But yeah, not every attorney does them. Some people rely on opening, a good opening, and that's okay too. For me, it helps me really understand the case. Socialista, again, I think Socialista, your medical issues are not the issue. The real question is whether you have credits. Block's fruit picture. I was wondering if your spouse is making $22 an hour to affect your benefits, not for SSDI. For SSI, yes. SSDI, your assets, stock market portfolio, rental house, nothing. It's only about your working. So if your spouse is working, doesn't make a difference. SSI, it would. That would be, they call it the deeming rules. And they basically take your spouse's income and associate most of it with you, saying you have access to it. But if it's SSDI, not a problem. Trish, how are you doing, Trish? Good to see you here. Okay. And Kelly Brickner, this is such a roller coaster. Husband was step 4, now back to step 2. It's been a year since he filed. Come to contact our congressional rep. Yeah, I mean, obviously there's something going on where they're doing more review. That's probably not a bad thing. But yeah, I think that, a year since you filed, long since time, contact your senator. I think senators are in office for 6 years. They tend to have more permanent staff. And yeah, I would do that. I let your lawyer know. But I think that contacting a U.S. senator would be a good idea. A good idea. Dennis, I think we talked about this before. Being 58, will you get a CDR? Probably not. Probably not. Guitar Gardens. Thank you for the tip, Guitar Gardens. I appreciate it very much. Guitar Gardens says, when submitting medical records, is it best to use PDF of about 1,500 pages from the VA? Private hospitals over 25 years span, don't overwhelm them with too much noise. Here's my thought. The VA is part of that HIT system, and Social Security will probably be able to get those VA records directly. Normally, when Social Security requests records, they get it for about a year to 18 months prior to your onset date. If you are working in that 25-year period of time, arguably these records are going to be of use for historical purpose to show you've had long-term problems, but they're not going to prove you're disabled. You were working. So if, let's say, you have records that were from 6 years ago, but you were working, all those records are going to show is that you were getting treatment for a condition, but it wasn't work preclusive. And literally what happens is Social Security, when they get the file, everything gets uploaded into your file. They look at it. When the hearing office gets it, they go through and they purge. They take records that are not, quote unquote, relevant, and they put them in something called the unassociated part of the file. And so the only thing that's going to be in the file the judge sees are the records from about a year and a half prior to onset. And so my feeling is, with the VA records, I would not submit them directly. Because I think Social Security is going to get them through that HIT technology. You can ask that, but my thought would be they can use, it's called health information. You look it up, health information technology, or HIT. And the VA is part of it, because I've seen it many, many times. So that's my thought. And as far as the private hospitals, I would get those records and have them available. Is it going to harm your case to submit them? No. But if it's for a time that was when you were working, not sure how relevant that's going to be. Certainly records from the last year and a half, they're going to probably get them. But is it a problem to submit them? No, not a problem to submit. So I would basically I would summarize it like this. If you can get records that go maybe a year and a half prior to your onset date, go ahead and submit them. No harm. It may be duplicate. They'll take the dupes out. No harm. I don't know that I would submit 25 years worth of records right now. You might put on one of the forms that you've got those records if they want them. If you get to a hearing situation, your lawyer can, decide whether those records need to be, put in the file. Realize that medical records will probably say that this person's been treating for the last 25 years. And since Social Security does not, need to have all the records authenticated, that's going to be sufficient proof that you've been getting treatment for that long. So that's my take. My gut feeling is not to submit 1,500 pages of records right away. Let them get what they can get and supplement it accordingly. And again, stuff that's really, really old, not sure how relevant that's going to be. Shub 281, 56, found disabled August of 23. Award letter says we're required to review in 5 to 7 years. What are the odds? Not great at 56, 57. It's just, you're not their target. And technically a 7-year review really means no review. It's the most far out, other than, I don't know if there's any notation that says no review ever, but 7-year review is basically saying that medical improvement is not likely at all. And at 56, it's not going to happen. I just think it's probably not going to happen. Vince, that's my comment about ice cream, I'm guessing. Christina Villarreal, good to see you, Christina. Share video in the live stream. Yes, please do. Thank you. And good to see you, Christina. Thank you for tuning in, as always. Adam Wright, hello from Dayton, Ohio. Never been to Dayton. I got a cousin who lives in Dayton, but I have never been there. I think I've been to Cincinnati one time. That's the only time I've ever been to Ohio. I'd really like to go to Canton. I'd like to see the Pro Football Hall of Fame. I understand Cleveland's really nice now. My son and I sometimes talk about taking a trip and going to see, let's say some baseball games and going to see the Hall of Fame and so forth. I hadn't done it yet, but that would be something I'd like to do. Not that that's in Dayton, but I know Ohio is a big state, but really have not been there. Florida Raider fan. Hello, you say Florida Raider fan. Are you in Florida and you're a fan of the Raiders, or is there a team in Florida called the Raiders? I don't know. End Times Armory. That sounds ominous. Does SSA give much weight to lay letters and VA health records? Is it enough to not schedule exams or send out forms if there's enough evidence? Lay letters, I don't think mean a whole heck of a lot. As I mentioned earlier, you get a letter from your wife or husband or your brother or your mom, they have an interest in seeing you approved, not going to carry a lot of weight. The only exception would be if there's a significant mental health problem, they can talk about what they've observed about the problems you're having. So, all in all, probably not a lot of value. Is it going to hurt anything? No. A letter from a former coworker, much, much stronger. VA records are relevant. I see them in a lot of cases. And obviously, if you're 100% VA disabled, that will get you to the front of the line as far as your hearing. So VA records is something Social Security is going to get. And, they may show enough to find you disabled. I realize a VA finding of disability is not binding on Social Security. But, sometimes there's enough in there if there's MRIs or CTs or other objective tests. It's just VA records tend to be hard to read because they're voluminous and a lot of duplication. But the answer to your question is, if there's enough in the VA records to prove your case, then Social Security may not send you out for consultatives or send you the forms. Possible. I'm also noticing, I'll tell you that used to be every case people were being sent out for consultatives. Maybe it's a money-saving thing, but there's an increasing percentage of cases where they're not sending people out for consultatives. I'm not sure why, but that's just what I've observed here. Jeff Brown, I was in a car wreck on the job, okay? Have not filed workers' comp. I was not at fault. Have a hard time blaming my job because it didn't cause my injuries. The woman who hit me is at fault. I do have an attorney for the personal injury claim. Wife is scared of me losing my job over this, so I file workers' comp. Would a workers' comp claim help or hurt a future SSDI claim? All right, complicated question, because you raise a lot of issues, Jeff. First of all, workers' comp and Social Security don't play well together. So if you get on benefits for workers' comp, that will offset Social Security benefits. So every month you get workers' comp, that's a month you don't get Social Security. So if somebody calls me and says, I got a good case, I'm 57 years old, I got 3 herniated discs, I've got brittle diabetic, but they're on workers' comp, I'm not going to take that case because they're getting workers' comp benefits. There's no past due benefits. I can't get paid. So, if you get on comp, it may make it all but impossible to get a Social Security lawyer. That's point one. Second thing is workers' comp is in most states, and I don't know where you live, but in most states, it's a primary kind of coverage. So if you get hurt in the job and you go ahead and submit your records to private insurance and they find out it's an on-the-job injury, they may refuse to pay for it because they're going to say this is a comp issue. You got to go through comp. And in most states, you have a certain amount of time to file your comp claim. And if you don't do it, you're barred. So you could unfortunately find yourself in a situation where you didn't file a comp claim and you can't, and the insurance company says, we're not paying for it because this should be comp. Even though you're not filing a comp claim, they're going to say that's what you should have done. It gets real complicated very quickly, as you can see. And then the question is, if you have a serious injury and you do go through comp, you could lose your job because, if you're going to settle the case, my wife does comp here in Georgia, and 99.9% of the time when she settles a case for $30, $50, $100,000, part of that settlement is a resignation. So it's not like you're going against your company. It's going because workers' comp is a no-fault system. In other words, you simply have to prove that you were hurt on the job or in the course of employment, and you're covered by comp. It's not about proving fault. Now you can pursue a third-party claim against the other driver, but workers' comp is primary. Here's what I would tell you to do, Jeff, because again, this gets complicated very quickly. I would talk to a comp lawyer in your state. And I realize that, you're not under the obligation to file a comp claim, but I would just talk to the comp lawyer and ask, what are the implications of me not pursuing workers' comp with regard to the private insurance and paying for the medical records or paying for private insurance, paying for medical treatment and so forth, just to get an idea of what the comp looks like and about, the likelihood of getting fired and so forth. Because again, comp lawyers are looking to settle a case. If you're not looking to settle it so you don't get fired, and then of course the insurance company may demand that you resign anyway because you're at risk to them. So point one is talk to a comp lawyer. I think it would be well worth your time. They'll talk to you at no cost in your state, where you got to do it in your state, because this is not a federal system. It's a state-by-state system. That's number one. Number two is that, in your state, comp may be a mandatory type of thing to do, in which case you might look at doing it. Number three is not pursuing a remedy available to you because you're concerned about, what the insurance company may or may not do. I got news for you, Jeff. The insurance company is going to do what's best for them. You're damaged goods at this point. You had an accident, you were hurt. You're agreeing, or your decision not to pursue comp, not to ask for a settlement, you think you're acting in good faith. They don't give two hoots about that. If they see you as a risk for a future injury, they're going to tell the employer, get rid of them. So don't do anything thinking you're going to, make the employer happy and give you your job back. If they see you as a risk, they're going to fire you anyway. So again, talk to a comp lawyer. This gets real complicated, but talk to a comp lawyer. Okay, I think we talked about that. KU Thunder. What is KU? I didn't. I think I may have asked you. Is it Kansas? Is it Kennesaw? What is KU? I'm just curious to what that is, because I know you're here a good bit. And I see looks like a bird there in your icon. Okay, you're welcome, Socialista. Okay, this is my comment about AI. End Times Armory thinks that AI will cause the Fed's unexpected issues with errors in documentation, also training the AIs to be regulated, or AI tool will have positive feedback loop. Yeah, look, AI is brand new, and or I'd say brand new, but it's kind of now that second generation where it's starting to become more mainstream, more valuable, more useful. I'm in an AI mastermind group with a lawyer mastermind group, and we meet once or twice a week to go over, using AI responsibly in legal matters. And it's a really powerful tool. It will save lots and lots of time. So, yeah, I think it's here to stay. It's not going away. And it does some interesting analysis. Now, I will tell you, and you probably have heard the term. If you're not, I'm going to tell you, there's a term called hallucination. So that's where AI will just use bad information and and basically provide bad information in what it produces. You probably heard the cases of lawyers submitting briefs that reference fake sites or imaginary cases, and they get called out on it. I did a blog post a couple of days ago for my Social Security blog. Go to ssdanswers.com blog, and you'll see I did a blog post recently about now I'm drawing a blank what I did it about, because it was that's kind of embarrassing. I just did it. Okay, for Lyme disease. That's right. I did it for Lyme disease. If you go look at it, you'll see. So I actually asked ChatGPT to draft a blog post. I gave it some resources, draft a blog post. And it drafted a blog post, and it wasn't a very good one. And it referenced something called the treating source rule in part of the analysis, which is no longer valid law. The treating source rule said that Social Security is required to use the records from your treating source, your longtime treating doctor, over doctors that you saw once or twice. They got rid of that years ago. And so if I took that blog post and just put it out there, it would say, oh, the treating source rule says it's wrong. So I had to, the positive is it gave me kind of a structure of something to work with, but I had to rewrite the whole darn thing for the most part, I'd say. But it saved me probably, if writing a blog post about Lyme disease from scratch would have taken me an hour and a half, it took me about 30, 45 minutes. So it saved me a bunch of time, but it was not accurate or correct when it came out of ChatGPT. Now, is there a way for me to prompt ChatGPT better to do better blog posts? Are there other AI engines that would do better? Possibly. Could I give, if I did it in Notebook LM and I gave it more information, limited sources, would that be better? Possibly. But, that's just an example of how, I used AI, in kind of a creative sense, and it really screwed up. I've also used it to say, give me some interesting, video topics, things people are asking on sites like Reddit and Quora and things like that. What are they asking about Social Security that I can answer in a video? Came back with some really good ideas. So, it's a tool. Everybody talks about AI is going to eliminate all these jobs. It may, but it's going to create new ones. It's a tool. It's just like the analogy would be when I was in elementary school, electronic calculators became a big thing. And literally when I was in high school, I had a teacher that taught us how to use a slide rule. I don't know, nobody here probably knows what a slide rule is, but it was actually this device. It looked like a ruler. It had like a thing that slid along it, and you could use that to do adding, subtracting, and math and all that. I couldn't tell you how to do it now at all, but at one point I guess I must have known. But then calculators come along, and so we've all got calculators that will give us I got 2 or 3 of them here. I don't know. I got this is it's got a cord on it, but I've got my phone's got a calculator on it. So I don't have any trouble multiplying things, dividing things, all that stuff. Do I understand the concept of what it means to multiply and divide? Of course. What does the calculator do? It stops me from silly errors. I mean, I was notorious and I was an English history person. I'm more of a writer as opposed to math guy. But I remember my algebra class, I would have a function. I would have to add 6 plus 6, and I would get 36 because I thought it said, I misread the plus for a multiply. Or I would, 6 times 6, and I would get 12, instead of 36. So it's just stuff like that. So calculators eliminated kind of these silly, processing errors, but you still have to understand the concept. I think AI is the same thing. You can use it to create an outline, to come up with some points, but a human being at this point still has to go through it and make sure that it's accurate, because otherwise you're asking for trouble. I haven't mentioned this, but I just want to mention a couple of things. You see in the crawl here, if you want a case evaluation, just go to the bit.ly contact Jonathan 3, and you can fill out for a case evaluation. I have a lot of people off the live stream reach out to me. Had a couple of people say, do I have a good case? If you want me to look at it in more detail, that's where you'd go to do that. So I don't want to forget to mention that, because obviously, looking to pick up good cases, always. Larry Plants, waiting for an ALJ hearing. How long have you been waiting, Larry? Normally I'm getting them in 5 to 6 months. It's pretty typical. I screenshot that form info. Sure, absolutely. Miracle after miracle. Sharon, okay, no news, I know. I know, trying to get your money. This is an ongoing problem. They are just, don't give up. We're going to get it. But Social Security, this is on the listserv. I'm seeing people writing in about this. They cannot get them to, there's some glitch someplace, or some box that hadn't been checked, and it's holding up the money. But congressional inquiry is the way to go on this. But we're on it. We're not going to give up on this. We're going to get you paid. Look, I'll tell you. I don't want to say this is going to happen to you. I had a case. It was a clearly winning case. My client had early onset Alzheimer's. He could barely talk at the hearing. It was a clear winner. Got the approval about a year ago. Okay, client gets paid. Jonathan doesn't get paid. I'm calling. I'm writing. What's going on? I got paid a week ago. I had to wait a year to get paid. No reason. Nothing. No reason I can see it all. Clear case. The guy wasn't working. He was in an assisted living home. No reason to hold up my fee. He got paid. It took them a year to release the money. This is just what's going on. They're so overwhelmed, so overworked, understaffed, that sometimes people aren't getting paid. There are lawyers, and unfortunately I'm not one of them, on my listserv. There's one guy who said he has gotten paid, and I don't know how many hearings he's done. He's gotten 2 checks this year. Well, try to run a business like that. I mean, where you're winning cases, you're taking in cases, you got to pay your staff, you got to pay rent, utilities. You've gotten 2 fees, and realize the max we get is $9,000, and most cases aren't going to go that high. So let's say he got $7,000, $14,000 for the whole year. How's he supposed to stay in business? This is what's going on. So I think, Sharon, this is what's happening here, is that somehow there's some red tape. Again, I've not really had it so much for me. I've got a few cases out there that I've gotten paid on, but I really have not had a huge problem with it to date. But it certainly could happen, and it has happened to me. So, but we'll stay on it. If a person does not qualify as DG for SSDI, but only SSI, how about getting legal assistance? There are lawyers who take SSI cases, and I will tell you the problem. I like to be real transparent. Problem with SSI cases is, number one, there's a lot of times offsets, support, family support, household income, a spouse's income, assets that you may own that would offset your SSI. So that's the first question I look at. And if somebody wants to do SSI, pursue SSI, and they're married and their spouse works, can't do it because there's no past due benefits. The second issue is that SSI, the amount that you get is capped at like $1,000. And if there's any offsets at all, it goes down from there. So the past due benefits are going to be a lot less. So the fees are, for an attorney, going to be about half of what they're going to be for SSDI. I'll take a few SSI cases, not that many of them. I refer out a lot of them just because, I've got only a certain amount of time, and I'd rather take the cases where I'm going to have a better chance of getting a larger return. But there are attorneys out there who will take SSI cases, and they're okay with a little bit less money. So, you may have to kick a few more tires and talk to more attorneys, but there are, I would guess, of the people who do this, at least 3/4 of them will take SSI cases, assuming there's no problem with the deeming rules. But they may be more selective in those cases. And that's the way I've looked at myself. I'll take them, and I'm more selective. I'll take an SSI case for somebody over 55 with significant medical issues. I'm not going to probably take an SSI case for a 41-year-old with, non-insulin dependent diabetes. It's just, the risk reward isn't there. So that's how I would tell you. When SSA asks for medical documentation, the originals not copies. What does that mean? Most records are copies. Yeah, I don't know what that means, because everything is a copy. I think just send in copies. That's what I do. So I don't see why they would not want them. I've sent them at reconsideration level. Ask for these evaluations. Yes. Okay. Yeah. Again, just go. You have to go to them and just tell the truth. RD says, I basically tell the surgeon who damaged my bladder with mesh I was not going to sue him. Asked him to document my bladder impairment medical records. He agreed. Yeah. Again, pursuing a lawsuit for a mesh problem, for medical malpractice, I don't do that kind of work, so I don't know how difficult it is, what the damages would be, that sort of stuff. You made a decision it was worth more to you to have records to help you with your Social Security than to pursue a medical malpractice case. And that's a legitimate thing to decide. Hopefully you did that analysis after at least talking to a medical malpractice lawyer to see what the potential recovery might be. Mr. Fix-It, my case record of my work history of the phone, no need to mail one in. Should I be concerned? No, that's pretty common. I've talked to adjudicators. In fact, I remember I had a long conversation with an adjudicator, I think in Oregon or Washington State, one of my cases. And he's like, yeah, I prefer to just do it by the phone. That way I can get it. I fill it in, send it to him to sign, and that's all good. So that's not uncommon. It's less and less common because the adjudicators don't have time, but some of them just like to do it, like to talk to the people. I talked to this guy and he was like, yeah, I'm trying to do a good job for these people. I want them to get approved if they should be approved. And, you have a few out there like that. Russell says, the doctor at the free clinic had me sign a release, got my records in order from all my visits the next day. Yeah, sometimes you can get your own records faster than anybody else can. Wilderbeest, 1970, won my SSDI case with ALJ. I'm 54. Date the judge found me disabled is July 7th. Have to wait 5 months for no back pay. Should I appeal the ruling? So my lawyer gets nothing. Again, they changed the onset date. I would talk to your lawyer, and in the analysis I do is, what is the difference? How much would you have gotten with the original onset date versus what you got, which is zero now? Is it $5,000, $10,000? Is it $20,000? Realize you had an ALJ hearing, so now you have to go to the appeals council, and to see whether or not there is grounds for appeal there. I mean, it may not be. I mean, sometimes you look at a case and the appeals council. I have an attorney, like I'll contact Carl Dosterhout or Brian Konoski, and I'll say, what do you think about this case for appeal? And they'll say, there's not a mistake here. I don't think it's viable for appeal. So in that situation, there's no appeal. So I think you need to have somebody look at it, but you may make a decision it's not worth it, but at least know what the numbers would be. Mr. Fix-It is 55 and 9% VA. Well, again, the 9% VA is not going to carry the day. Your 55 to me is more important. That's to me, that's a bigger deal. Wilderbeest says, I think the judge made me a favor not meeting the grid rules and I was found disabled. What am I risking to file an appeal? My lawyer is suggesting maybe 18 months. I think there's always a risk when you appeal because you go back for another hearing and it's a brand new hearing and you may get a different judge. Is it a big risk? No, but it is a risk. So you have to make that decision about, whether or not it's worth it financially to pursue an appeal of a favorable decision or partially favorable decision. Simple Life Soon. Does a pain journal or photos of flare-ups help with SSDI? I think it does help. I think that a pain journal can be very helpful. Photos can be part of the record. Yeah, I think it helps. Absolutely. Because a pain journal is, gives you kind of what they call longitudinal evidence of a problem. And I think that can go a long way to, a judge recognizing that this is not a temporary kind of thing. It's ongoing. What's the best way to update Dreamers Club in my bank account? I can't access online because of my hearing coming up. Can't do it online. Call because the closed office is not close by now. Well, I mean, if you win, then you'll be given the number of the field office. You can do it then. You could theoretically, I think that's really the best thing to do is just to, contact, maybe you could, again, go to that ssa.gov/locator. You could mail it in, presumably, but I think this is one of these situations where it might make sense to try to get somebody on the phone. As hard as that may be to say, or wait till you get approved, and at that point they'll reach out to you, and you can update it then. But yeah, I would try to, if you could be proactive, that would be good. T Cash, thank you for the show. My pleasure. 62 years old. Onset, it was 2 years ago. I got the back pay. If I use the Ticket to Work program, I have to pay. No, you do not. Ticket to Work is, I think, forward looking, so you would not have to give up your back pay. I don't know much about the Ticket to Work, but I know that would not be the case. Gun Lover, how does SI determine the value of work for CDRs? Was told it's just a number. 1620 is also the value of work. Well, 1620 presumes if you're earning $1,620 a month gross, that is presumed SGA. So you're at that level or over it, that means you've returned to work for their purposes. If you've done a volunteer work or gone to school or doing something, where you're not making money, but it's equivalent to that, if they make a decision, let's say you got a position as a docent at a museum, and you're doing it 6 hours a day, or you volunteered at a school cafeteria, or you volunteered at a homeless shelter or something like that, where you're doing something that otherwise would result in a payment, that's what they're talking about. So 1620 presumes it, but the value of your time, if it would be, what would a 6 hour, a person in a museum getting minimum wage or whatever the minimum wage in your state is. Now realize some states have higher than the federal minimum wage. I mean, Oregon and Washington, for example, I think it's like $15 or $16 an hour. So, I would assume that if your state has a minimum wage of $15 or $20 an hour, and you're doing, 6 hours of volunteer work, multiply it out, and you'll see you're probably going to come pretty close to that 1620. So that's what they're talking about. It's just figuring out what this would look like if you took your hours and multiplied it times the reasonable value of a job like that, whether it's minimum wage or more. If you're doing something that requires training or skills, it may be more than minimum wage, but that's what they're talking about. Michelle says, this great question, Michelle. Receive the internet application summary. So when you file online, they will send you in the mail a printout, a summary of your application, and ask you to review it and sign it and send it back, which you got to do. It also says, send us medical records, and if you've got them. And, should you do that? Again, I think if you can go through your portal and do it, upload them, that's better. I don't know anybody. I'm not a big fan of mailing stuff in because I think it's going to get lost. If you do it, just make sure you have another copy of it because you may need to do it again. But definitely sign that. That's up to you. You got plenty of time to get those records in. I would just say you're better off doing it electronically. I just think that when you mail them stuff, it's got to go through a mail room. It's got to be scanned. It's not a big fan of that. So you could do it, but be prepared to do it again. And I would get those records scanned. And then if there's a portal that you can access to through your My Social Security, you upload them that way, or even do it by fax with the barcode. But I'm not a big fan of sending it in by mail with that thing. But do mail back the signed acknowledgement of the application. Muley says, though, you're welcome, Muley. Okay, we are down to just a few more minutes, and I'll kind of zoom through a couple more of these. End Times Armory, is a mental health claim enough for SSD if the condition causes memory loss and disorientation? The claimant has major depressive disorder, uses his girlfriend to drive him around to ask help. I think that, the symptoms you're talking about, certainly the question is, would they prevent this person from doing a simple entry-level warm body job? Sitting at a table, putting ink pens in a box. You don't have to have a memory to do that. More importantly, do you have a doctor, a psychiatrist or psychologist who's willing to go on record to say that this individual, has the following functional issues because of his depression, unable to, significant memory loss, and really get a functional capacity form filled out. Emotional stability issues, crying spells, episodes of, person would need to be in bed all day. It's all going to be about reliability. So your testimony, the person's testimony is going to be marginally a factor. It's really going to be what the medical record says. You're going to have strong support from a mental health professional. Okay, Raven Poe. Does the rule for people that have transplant that make them eligible for SSD bypass the work credits? No. If so, what you're asking is, you have a medical record that says you need a heart transplant, a liver transplant, a lung transplant, or whatever. You probably meet a listing or a compassionate allowance and you win medically, but you still have to have credits. So those are two different things. One's about qualifying for the program. One is for qualifying medically for disability, meaning the definition of disability. You still have to have credits. Are legal aid disability lawyers decent for disability situations? I think some are not. I mean, legal aid lawyers, wear a lot of hats. They work really hard. They a lot of times deal with criminal stuff, evictions, maybe some domestic stuff. I don't know how much they know necessarily about Social Security. My experience with legal aid lawyers is that there are some that make a career out of it, and they kind of know a lot about a lot of things, including Social Security. There's also younger lawyers who work for legal aid, and they do it for 2 or 3 years, get the experience, quit, and move on. So it really depends on the person there and whether they know enough about Social Security to properly advise you. Realize that a private lawyer, like me, or like Stephanie, or like any of the lawyers I've had on here, Chad, we work on a no fee unless you win. So assuming it's a case that's viable, there's no upfront costs. There's no cost unless you win. We get paid in past due benefits. So if your reason for getting a legal aid lawyer is because you don't have money to pay a lawyer up front, that's not an issue, because we only get paid if we win, and based on past due benefits. So the question is, would a legal aid lawyer who would charge you nothing, is that better value to you than somebody who's done it for 20 or 30 years who gets paid a percentage of past due benefits? That's a judgment call you're going to have to make. But I would certainly, if you're going to go legal aid, and maybe because you can't find somebody, a private lawyer to take it, talk to them about their experience with this, and see what they say. Okay, time for a couple of more. No snags was estimated time for case decision from the time goes to DDS, 8 to 12 months. 8 to 12 months. Thank you much. Good evening. Anything wrong with submitting third-party forms and functional? No, nothing wrong at all. Good idea to do it. Go for it. Absolutely do that. Okay, getting laid off because of health issues. You can qualify for unemployment. Does not bar you from pursuing disability. And again, I'm not an unemployment lawyer, but I think if they laid you off, you should be able to pursue unemployment. I don't know, again, I don't know your state's laws, but certainly file for it, see what happens. But it's not going to stop you from pursuing disability. Okay, this is going back to the workers' comp question. You mentioned the employer sees a risk that if fired by employers aware of a new illness, difficulty to work, something I should worry about. Again, I don't want to offer. You've been there 15 years. Again, I don't want to offer advice about Americans with Disabilities Act, your state's labor laws. I mean, every state's going to be different. What I can tell you universally is that insurance companies are out for insurance companies. They're not going to, give you special treatment or do anything nice for you because you were nice enough not to pursue a claim. Just not going to happen. So again, I think you need to talk to somebody in your state about workers' comp, just to get a sense of where you make a decision, an informed decision. And again, is there an ADA issue here? I mean, there's a lot of things going on, but I think I would talk to a state lawyer with workers' comp, certainly. Okay. We are going to make this the last question. I got two more. I'm going to get two more. Asha and Ms. Jordan. That's it. And I'm going to go. This got done after a second time with DDS, gathering most of my disability records, submitted to their doctors for osteoarthritis, mental health evaluation, depression, anxiety. What's next? 54, male, just turned 54, been 20 straight months. No denial letter or anything like that. I think I have a chance for me to die. The first time I was 46. Sorry if I have some questions. Questions are fine. You're 54, which helps. Again, it's going to depend on what the records say, because it's ultimately boils down to is the medical evidence support the argument that you would not be reliable at a job. 8 hours a day, 5 days a week. At 54, you could argue for if there's physical elements to osteoarthritis, then you might meet a grid rule, a sedentary grid rule, which is where you have to prove you're limited to sedentary work. So, the fact that you were denied at 46 has no bearing on this at all. That's a long time ago, and different standards and different rules. There's a 5-year look back for past work as opposed to 15 years. You're in a different age category. That means nothing. So yeah, pursue it. Try to make a grid rule argument if you can, and see what happens. But what you did before is not going to have any bearing on it. Being 54 will help you. When you turn 55, it's going to make it even easier. And again, you may find them change the onset date. Okay, Ms. Jordan says, going 100% disabled, unemployed veterans be denied. Yes, you can. Different standards. They can deny you. Tom, attorneys not local, as you hear me by phone, it'll be phone or video. Yes. Okay. What does it mean when the online portal says step 2 non-medical evaluation was done with TDS? It just means that they've decided you have enough credits for disability. You qualify, in terms of your earnings record. And now they're doing a medical review, which means they're looking at the medical side of it. So there's a non-medical, which is do you qualify for the program, and then a medical. And so it looks like you qualify for the medical, or qualify for the non-medical, which is good. Me, Stephanie Evans, Disability Yoda. Thank you. Appreciate it. I don't know Evans' disability. I have to check them out. And Yoda, Greg is a nice guy. He emailed me this week about something. Okay. This is going to be the last one because I got to go. We're already 6 minutes over. My award letter says I'm insured until 12/31/25. Does it mean I lose my benefits? No. It means you're grandfathered in. But as long as you're found disabled before that date, you're grandfathered in. So you don't lose your benefits at that point. It just means that if you're found disabled after that date, that's a problem. Now, if you have a CDR, I believe that your insured status, I don't know this for certain, gets held while you're on benefits, but even if you had a CDR afterwards, that doesn't mean that you're not going to be insured anymore. So as long as you get approved before you're on your date less insured, you're golden. So you got an award letter, so you're good to go as long as they don't terminate your benefits down the road, but you don't lose them in December 25. Okay, that is it for today. We've been at 2 hours. You know what? I stand corrected. I started a little bit later than I normally do. I got 8 more minutes to go, so let's do it. Okay. Thank you for being amazing, and certainly appreciate it. Sure. I don't know if everybody would say I'm amazing, but I'll take it. Okay, thank you. I just realized I started at 8:45 my time. Press the thumbs up hard. Okay, very good. Okay, I kept talking about this is it. People stop asking questions. So let's see if I got any more here. And then it looks like that's it. So yeah, I kind of got ahead of myself. All right, so we can end it now. It's at 1:50, 1 hour. Unless anybody's got any more questions, go ahead and pop them in. Okay, we got one more here. I'm 54, turned 54 with my hearing. It's a possible age will approve me on my birthday. When I turn 55 and lose my back pay. The question is, if your approval is issued after you turn 55, the judge could theoretically find you disabled as of your 55th birthday. And if the decision takes a month or two to be processed, the judge could hold it until you turn 55 and then approve you as of age 55. Could do it. Doesn't mean he will or she will. They could do that. So yes, that is a possible issue there. And I'm seeing more and more Social Security doing that, screwing around with people's onset dates to eliminate past due benefits. Put this in there here. If you find this valuable, please leave me a review. I've gotten some really nice reviews. I got one person left me a nasty review. I won his case, and then left me a nasty review because nobody would call him. He wouldn't tell us what he wanted. Nobody would call him, and left me a 1-star review. So what are you going to do? But if you find this live stream useful, please do leave me a 5-star review, and then that will help a good bit. Okay. All right. Looks like it's all the questions I've got. People are starting to drop off, so we're cool on that. So again, I appreciate everybody coming in tonight and spending your evening with me. Let your friends know. I want to try to grow this. I think we had about 140 at the most today. Trying to get it closer to 200. So if you know people who are interested in disability, please let them know and tell them to join me on Wednesday nights. I've been doing it at 8:45 just because, and I'll be honest with you, I'm playing tennis, and it's still light enough. So the courts I'm playing in are not lit. So I played, I started at 5:30 today, finished up about a little bit before 8, came home, took a shower, shoved down some food, and here I am. As the year goes on and it gets darker a little bit early, I'll go back to 8:30. But 8:45 is also gives some of the people on the West Coast a little more time to get on. So I'll see you next week at 8:45, and I think I've got a guest next week. I think I've got Spencer Bishens is tentatively lined up. Spencer used to work for Social Security, so he's going to talk about what he learned when he was there and some of the things that happened behind the scenes. I think it'll be real interesting. So again, if you know anybody who's interested in Social Security disability, please tell them to join us. So for that, this is it for me, Jonathan Ginsberg here. I'll be getting some new videos out, so keep your eye on the channel, and we will see you next week. Thanks a lot.